So let's look at how does the provision of MAP gets implemented under the Indian domestic laws. Okay. Now the case could be falling under two categories. First one is, like I told you, there could be an Indian taxpayer, there could be a US taxpayer, right? The problem could be with either of them, with the competent authority of other contracting state. So a US person may have with Indian competent authority, right? The Indian taxpayer may have with US competent authority. So Rule 44G and Form 34F deals with a case where a resident assessee is aggrieved by any action of foreign tax authorities. So what we are looking at over here is that an Indian taxpayer is aggrieved by the action of the US competent authority. For him, the way to go is Rule 44G and Form 34F, right? As against this, Rule 44H deals with the action by the Indian competent authority on reference from foreign competent authority. Now let's understand in this case what is going to happen. In this case, this US taxpayer may have a problem with the Indian competent authority, right? But he's not going to go and approach the Indian competent authority directly. Same is the case in first case as well, right? He is going to approach his own competent authority in the United States, and then if this competent authority believes that the case is fit for discussion, they are going to make a reference to the Indian competent authority. In such a case, the action that has to be taken by the Indian competent authority on reference from the foreign competent authority is something which is covered by Rule 44H. So let's first see Rule 44G. There is an aggrieved resident assessee, right, for an action taken by tax authorities of foreign country. He believes that the taxation which has been meted out to him is bona fide, not in accordance with the terms of the treaty. This provision is actually centered around these few words. The taxation should not be in accordance with the terms of the treaty. If the taxation takes place as per the domestic laws, right, then MAP is not a remedy. But if the taxation is not in accordance with the provision of the treaty, that's where MAP comes into play. In such a case, he has to file an application in Form 34F to the Indian competent authority to invoke a mutual agreement procedure. And after that, the Indian competent authority is going to have a round of discussion with the foreign competent authority, and they may come together to a conclusion which is communicated to the assessee. This rule deals with the action by the Indian competent authority on reference from foreign competent authority. So the procedure I elaborated it to you, but let's go through it again. There is a foreign taxpayer who believes that the taxation which has been meted out to him by the Indian tax authorities is not in accordance with the provision of the India-USA Treaty. He approaches the foreign competent authority, and the foreign competent authority believes that it is a case which is fit for mutual agreement procedure. They are going to make a reference to the Indian competent authority, right? And the Indian competent authority is going to call for and examine the records relating to the case. Now these records will be lying with the assessing officer, commissioner, depending on wherever the matter is pending, right? What the Indian competent authority is going to do is they are going to call for the relevant documents, the records, and everything to assess what stand was taken, why that was taken, and is it a case where a stand which has been taken may need some changes, amendment, or does it means that, effectively whatever has been taken is right. In order to arrive at that decision, they are going to seek a response from the tax office and take a final stand. The stand they are going to discuss, negotiate with the foreign competent authority. The two may agree and arrive at a resolution Like I said, the resolution could be to agree with each other on taxation or non-taxation, or they could agree that they cannot arrive at a common consensus and therefore they agree to disagree. Once the resolution is arrived at, it is communicated to the DGIT or the Chief Commissioner. The AO has to give effect within 90 days of the receipt of the resolution from the CC or the DGIT, provided the assessee accepts MAP between the two competent authorities and he withdraws the relevant pending appeals. In such a case, the AO shall give effect to the MAP resolution.